Morning, everyone.
Good morning, Your Honor.
Good morning.
Good morning.
All
Good
right,
morning.
this is our motions calendar. I think we've got some matters where folks have requested to come off, so let's talk about those first. Let's start with Gulf Line Transport, the Falcone Global. I think there was a last minute request to continue this hearing. Someone wants to be heard on that?
Yes, Your Honor, this is Robert Kaufman. I am the attorney representing Falcone Global Solutions, one of the named defendants in the case. This is essentially a suit on an open account. There is a pay when paid provision that really governs the relationship between the parties. Up until last night, there was no allegations made in the complaint that in fact we had been paid, my client had been paid, which would have triggered obligations on our part to go ahead and pay the plaintiff in the case. There was a late filing last night of an amended complaint, which we received. The amended complaint attached a schedule, which is a bit confusing to us and may be somewhat inconsistent with the allegations, but it may not. And what collectively the attorneys have decided to do is to seek a continuance and give us an opportunity to look through the information that's been supplied. It's a bit complicated because there are several parties involved. There's a factor involved. Each entity seems to use its own reference numbers for payments and things of that nature. But I think within a couple of days, we will be able to sort that out. Plus, we've scheduled 3 depositions for the end of the month, which we're hoping to avoid in order to reduce any costs and expenses in the case. So we think the most prudent thing to do, Your Honor, would be to continue the matter, give us an opportunity to look through some of this new information that we've just received, and then we can report back to the court. And all of the parties have joined in.
All right, do we have counsel for Gulf Line?
Yes, Your Honor, Beth Rogers and Jamie Carroll.
All right, so it looks complicated to me. I'll say that much from reading the papers and the extensive paperwork that was supplied on both sides. Obviously, if y'all can get together and figure out what the operative facts and the operative terms are and resolve it, that's definitely better for all sides than having to try and sort this all out and educate somebody who professes not to know all the ins and outs of these kinds of business relationships. But if I will go ahead and continue it. We're going to, we'll put it back on for hearing. So it may not be too long. It could be in the next 60 days. So, if you're going to work it out and get together, let's do it now so that we can get it moving forward when it comes back up again.
Thank you, Your Honor. I'm confident that we'll be able to accomplish that in relatively short order.
That is fine with us as well.
All right, very good. You all may be excused.
Thank you, Your Honor. Have a great weekend.
You too.
You too.
All right. Position 2 was Fisher versus Gibson Jr. I think the court excused those parties from appearing because there was a settlement reached on that one. All right, let's talk about Neves versus Alavala. I had a last-minute conflict come in from Dr. Crone's attorney. I will just, tell the parties who are here today that I don't intend to set it down for another hearing. I intend to rule on the papers, and it will be a very simple ruling. Not going to say what that ruling is, but Mr. Calabro and Ms. Bauer, you probably know what that ruling is going to be based on the paperwork that was that was filed and the supporting documents that were filed along with it.
Okay,
That ruling will be entered in short order, and then
Judge, the only issue I'm not clear on is, I guess I'll have to look back at the order. I thought because there was a conflict, we weren't going to be arguing today, but
and absolutely not. I don't. Yeah, I don't want y'all to argue today, and I'm actually not going to hear any argument.
okay,
I'm just going to rule on the papers.
all right. Thank you so much.
All right.
Thank you, Your Honor.
Thank you. Y'all may be excused.
Are we excused? Okay,
Yes,
thank
you're
you.
excused.
Have a good weekend.
Do. All right. That leaves us with the only matter that's going forward today is Lane versus M Entertainment Properties. We are here on part 2 of the motion for attorney's fees. I have already granted the motion in terms of deciding that fees were warranted under 915-14. The purpose of this hearing today is to have a hearing on the amount of those expenses. So I'd like to give defendants the opportunity to make any presentation they want to make and present any witnesses they want to present. And obviously the plaintiff side will have an opportunity to either examine or cross-examine or make their presentation as to why certain fees or expenses should not be awarded. So I will turn it over to defense side. Will that be you, Mr. Freed?
It'll be me, Your Honor. Tom Grant here for defendants M Entertainment Properties, Paradise Entertainment Group, and M Entertainment and Consultant Services. I'm here with my partner, Gary Freed. He will do a lot.
Hold on for a second. I've got my court reporter who's raising her hand.
Thank you, Judge. I just wanted to inquire if the parties want to have this taken down.
Yes, ma'am, please. The defendants do.
And are we sharing in that on the plaintiff side?
Yes, we
All
are.
right, thank you.
All right, I'm sorry, Mr. Grant, go ahead.
No problem. I'm here with my partner, Gary Freed, who will do a lot of the talking because he has overseen this case from cradle to grave and has been involved in it from the outset through today and is familiar with the case and our fees.
All right. So go ahead with whatever presentation that you want to make. Obviously, I know that you filed the invoices, and I've read the affidavit, but anything else you want me to know or present before we give the plaintiff side an opportunity?
Thank you very much, Your Honor. I do appreciate that we are in part 2. I'm aware of the court's ruling. I don't want to rehash that, but as Your Honor is aware, this was a fundamentally flawed case that lived a very long life over many years. And so I just want to make sure we establish the basis for our fees and the many issues that we've had to deal with during the course of this litigation, which has spanned 2 cases with 4 complaints filed in 2 trial courts and 2 attempted appeals. As Your Honor has noted, the court has already awarded fees under 915-14A and B. And we would just remind the court at the outset that this is a case that never, ever should have been brought in any court. There was a clear failure to investigate. There was apparently no attempt to interview one of the main witnesses, Mr. Carl Radel, who subsequently actually contradicted his alleged testimony. As Your Honor has noted from the get-go, the video of the incident absolutely fails to support, and in fact contradicts this crossfire narrative that has been one of the fundamental bases for the complaint since this thing started. On top of that, there's been misrepresentations as to people standing as a guardian and administrators of a state, discovery misconduct, failure to appear at hearings for motions for summary judgment. And it's especially important in this case, not that it drives it, but it's significant that we had no insurance available for the defendants through no fault of their own, and Mr. Freed can touch on that. But as far as abuse of process and really causing damage to real businesses, that's very much the case here. Again, they should never have had to spend a penny on this. And instead, as Your Honor has seen, there's well over $250,000 in fees that have been incurred. As the court is aware, the issues today are going to be the amount and reasonableness of our fees, which have been submitted to the court, both in the form of the invoices that are unredacted that we submitted and have served on the other side. Almost all of those were served back in November of 2020, so they've had plenty of time to look at those. We have yet to see any filings from them in this case, but obviously entertain whatever they have to say before Your Honor today. May I share my screen for a second?
Yes, I need to give you permission.
Oh, okay, so I should have asked for that at the beginning.
All right, you should be able to share your screen now.
Okay, bear with me 1 second. Before I get into some more of the details and then pass the baton to Mr. Freed, I did just want to kind of give an overview. It's our position that, again, the fatal flaws, the misrepresentations, the failure to interview and investigate made this flawed from the beginning, and we therefore contend that all fees should be allocated to the sanctionable conduct, because, again, this case should not have been filed, as I think Your Honor even recognized in an October 2017 hearing. And even gave, I believe, opposing counsel at that time an opportunity to basically tuck tail and run away. But instead, as Your Honor recognized at the last hearing, they doubled down and they just kept on going forward. Again, we argue that all $265,802.74 in fees should be sanctionable, but we did just want to provide an overview to the court, depending on the approach that's taken. Because of some difficulties with insurance coverage and attempts to get that, there was a third-party complaint component to this case, as Your Honor may recall, and that did consume approximately $42,500 in fees. And so I just wanted to put this before the court and put that out there. Another possible line in the sand or point of possible consideration would be, Your Honor will recall that on September 15, 2016, we sent a very detailed letter summarizing video and provided video to plaintiff's counsel. And certainly if there was any confusion up until that point, when they saw the video, and Your Honor noted, I think at the October 2017 hearing, the video absolutely contradicts and does not support any of their claims. And so we would contend that at the very latest, even if you wanted to give any benefit of the doubt, this thing should have been shut down and ended at that time. And so the total fees that were incurred after we provided the video and the explanation, those are $240,667.61. And again, we illustrate here backing out the third-party complaint cost, if that's something that is at issue. The work that was done before September 15, 2016, you'll see consumed about $25,000. We've also had to deal with an appeal to the Court of Appeals and then a petition for writ of certiorari to the Supreme Court. That consumed about almost $17,000 in fees. We have not sought those. We didn't file any claims for frivolous appeal.
Your Honor, I'm prepared to speak if permitted.
Yes, sir. Go ahead, Mr. Freed.
So, Your Honor, I represented Magic City for over 20 years. I've defended a number of premises liability matters. When this case was filed, we did our typical due diligence and looked at the videotape and interviewed witnesses, and realized very quickly that this was a premeditated hit. It was not foreseeable that someone would walk up to the car in a parking lot and shoot the passenger and the decedent. And of course, that's tragic. The shooting did not occur on property owned by Magic City. It was owned by the parking lot company, and I tried to explain that to Mr. Washington at the get-go. I even gave him the contract with the parking lot company to demonstrate who the proper parties were. What we came to learn, and I don't want to dwell on this because the court has already ruled, but the court never really had at the beginning proper subject matter jurisdiction, since the plaintiff was not the guardian ad litem of the decedent's child and was not properly appointed administrator of the estate. And we raised those issues pretty quickly with Mr. Washington, and it did, in addition, in September, provided him with a videotape and an offer to sit him down, even with our client, and walk through that to show there was no crossfire narrative, that we had video of the shooter going out the back door of the club and his decedent client going out the front door of the club, and the person getting a gun and shooting him. And there was no way to prevent it. There was no crossfire. So ultimately, after going through all of that and failure to make discovery by the plaintiff, the case was dismissed. Magic City's CGL carrier went into receivership, and the receiver fund ran out by the time this suit was filed, so it became self-insured. I was with a firm for a while, a large firm, that another firm, and decided the rate structure did not fit my client base, amongst other reasons, and started my own law firm, which handled the majority of the litigation, and we made appropriate discounts with our client to set off some of the high fees. But all of the fees incurred after the video was provided to Mr. Washington were with our firm, and the fees were greatly reduced. While we filed a third-party complaint against the security company, in which we had an indemnity agreement, and the carrier brokers for the security guard company, because it's apparently the certificate of additional coverage that was provided to the security guard company, LA Security, was fraudulent. And so it didn't have coverage for us either. And we brought in the broker JLM, we brought in the insurance company Evanston, we brought in brokers Sweat and Crawford. So after the suit was dismissed, this is, to me, the main problem. Everybody said, let's try to get this case settled. And we set up a mediation with Henning. And that mediation was supposed to occur on July 27th of 17. And attorneys for all of the third-party defendants and the defendants were in attendance with Ken Kendrick, who's a very prominent mediator at Henning. And we were going to try to resolve this case, because it's very expensive to litigate these types of cases. Not only did it not settle, but on the morning of the mediation, Mr. Washington filed the renewal lawsuit. So he sabotaged any effort to try to resolve this matter amicably, and doubled down on his narrative. So throughout that matter, there was failures to produce his client in a second deposition. And the first deposition on May 2nd, she admitted basically everything that we had contended. She had not even seen the discovery answers. She had not seen the discovery. She admitted that the decedent had 2 children, that the second child was in Alabama with the decedent's mother. And the most egregious part of that is that Mr. Washington was the probate lawyer. So he knew that there were no letters of administration. So the petition filed with the court, and then in the renewal action and with the probate court, just say false things and inconsistent things to suit the ability of Mr. Washington to prosecute this lawsuit. There ultimately was no evidence. And one of the things, I'm not mostly a plaintiff's lawyer, I do mostly business work. But I do know when you're in a litigation matter, one of the first things you do is interview the witnesses. Well, the key witness was the passenger in the car with the decedent who was also shot. And when we got in touch with him, he had never been contacted by Mr. Washington. And his version of the facts were diametrically opposed to the theories that Mr. Washington was alleging in this lawsuit.
All right, so Mr. Freed, I'm going to stop you. I recognize sort of the visceral reaction and having had to deal with this for you personally and your clients over a long period of time. But I don't want to distract from the purpose of this hearing, which is to talk about the amount of the fees. Every argument you've made, I have substantively accepted, which is why I granted the motion for fees. So what I really want to get to, is not whether there was merit and, whether the proceedings was unnecessarily expanded, but the work that was done, why it was done, why it was necessary,
Yes, Your Honor.
and the amounts billed.
Yes, Your Honor. I understand. Just having focused on this yesterday and today, the facts of the case astounded me. But let me talk about the fees. So I supervised the conduct. I reviewed the fee, the billings that were sent each month to my client. We thought that, all of the fees were necessarily incurred. The appellate fees obviously are not by law obtainable in this proceeding. We also thought, for purposes of just trying to be fair about it, we backed out all of the fees related to the insurance coverage issues. Those total $42,500. So
let me ask this question from the invoices, and I will confess I haven't done a deep dive into the invoices. I know that they're there. Are there items that show the fees from which I can go and pick out which entries were not being billed for, or do we have just clean copies in the record of the total amount? In other words, because Mr. Grant put up a chart and said, well, we backed out this amount of fees for the third-party complaint, and we backed out some fees from before the time of the letter and presentation of the videotape. So is there a way for me to sort of double check that and make sure that the numbers being backed out are correct?
And one of the things I do need to say, Your Honor, I failed to say this, I'm testifying as an officer of the court under oath, and the testimony I'm giving is true and correct. I reviewed the invoices yesterday, and the simple thought was that everything after the video was presented to Mr. Washington, accepting the fees related to the third-party complaint and the appeals, should be compensable. And that number is $198,167.61. I went through those invoices. They've been submitted to the court. They have not been redacted. And I determined that the work was necessary. There were various billable rates. We also did not include, we gave discounts to Magic City for the high fee structures. That was allocated, so the number is a net number. And we believe that number was necessitated in this case to deal with the discovery issues, to deal with the evidentiary issues, to deal with the motion issues, to deal with a myriad of things that needed to be accomplished and defended because it was a wrongful death suit in Fulton County State Court. And we all know juries can do a lot of things, and we took it very seriously. Is there a breakdown by item of category of response? No, we didn't do that, but we can do that. Our position is there was no, as the court found, there was no evidentiary basis for this lawsuit whatsoever from the beginning. And so we determined that, in our opinion, we should exclude the fees from the date that the video was provided, when it became patently obvious to everyone that the theory upon which the plaintiff rested was false, and that the actions occurred on property not owned, controlled, or operated by Magic City, and that this was an unforeseeable event by someone who decided to shoot this plaintiff.
So what would be helpful to me is if there was some way for you to designate on the billing statement which ones you discounted for being related to the third-party complaint and which ones were discounted for being related to the appeal. I think I think what Mr. Grant proposed in the chart that he showed me, I think is a fair basis to start to reduce the fees by that amount. But I want to be able to look at the bills and be able to fairly easily say, okay, this one, that one, and that one related to the third-party complaint, and this one related to the appeal.
Your Honor, if I may, the court will notice there's a substantial gap between, we filed almost all of our invoices back in November 2020. And then earlier, I believe this week, Your Honor, I did a supplemental filing with 2 additional bills that just catch the time spent at the last hearing before Your Honor. And the reason there's a gap between there, in addition to COVID and other things, is because of the pendency of the appeal. So we pulled the invoices for the appeal. So the only thing we would need to net out, if Your Honor wants specificity, there would be the third-party complaint-related documents, and then the write-downs, of course, and the discounts that Mr. Freed referenced are already on the face of the bills and reflected in the amounts summarized in his affidavit.
All right. Thank you, Mr. Grant. Freed. All right, so I interrupted you there, so you can.
No, that's fine. I can just testify all of the work was done under my supervision. Clearly, as our client was uninsured, not that it would matter if it was insured, the work was done necessarily to address the multitude of issues that came about in what we thought was a baseless lawsuit. I can easily take the invoices that were submitted. I do think there were a couple of invoices that addressed the appeal, but that number is not included in the total that we have presented to the court. And I'm prepared to defend the invoices, discuss them. If any counsel wants to talk with me about them, we could probably break them down and with color codes and show which are the appeal, which are for third-party complaint matters, and leave the rest unless the court wants a further breakdown of the fees and costs, which we would be happy to do.
All right, so before I'll ask you for a further breakdown, unless y'all have anything else to add on your side, I will turn it over to Mr. Jerusalem and Mr. Washington.
Your Honor, if I may, just as a evidentiary nicety, I know Mr. Freed has stated his place, but just so we're clear for the record, if necessary, I would just like Mr. Freed to talk about his education and experience to support his opinion about the reasonableness of the rates that were charged in this matter?
Your Honor, this is Kurt Kastorf, who will be speaking on behalf of the plaintiffs. Tom, if it obviates the need for that, we're not going to argue that the hourly rate is unreasonable here.
Okay.
Otherwise, the hearing.
And then also, again, maybe just as a matter of housekeeping, especially since we're doing this remotely, the exhibits to Mr. Freed's testimony, they've already been filed. They would be the notice of filing, invoices of attorney's fees that we did on November 12, 2020. And then this week, the supplemental filing of invoices that we submitted, as well as Mr. Freed's supplemental affidavit filed this week as well.
Those are all in the record.
Okay, and Mr. Freed, are you familiar with those documents and have you read them all?
Yes, I have.
Okay, do you find them to be true and accurate representations and recordings of the time that was spent on this matter?
Yes.
And do you, having read your supplemental affidavit, stand by all of the allegations in that affidavit as you sit here today?
Yes.
Okay. Thank you. Thank you, Your Honor.
And Your Honor, I can just add, I've been practicing for 40 years. Been active as president of a DeKalb bar and the State Bar Board of Governors on a number of committees. Professionalism and ethics is very important to me and the way I run a law firm. And this is an anomaly in my career as to how it's a textbook case of how a case should not be handled.
All right, Mr. Freed, thank you. All right, so it sounds like, Mr. Kastorf, you're going to be sounds like you're going to be taking the lead on the plaintiff side.
Yes, Your Honor, and by way of background, I am new to this matter. As the court surely recalls, when it decided to award fees, it indicated that the fees would run against the plaintiff's counsel personally. And so under those circumstances, we thought it made sense to have an outside counsel sort of join the team and talk through the reasonability of the fees. So I'll be handling the majority of this hearing unless there are kind of some factual issues that Mr. Washington needs to weigh in on, and then, advising counsel on how to proceed after the court's issued an award.
All right, so go ahead, Mr. Kastorf.
Thank you, Your Honor. We would like to state, for the record, we'd like to, maintain an objection to whether the award of a fees is appropriate. I'm not planning on presenting an argument on that because I think the court's been quite clear in how it's going to come out on it. But we would like to talk about the reasonability of some portion of the fees. And if it's okay, may I have permission to share screen?
You should have permission. Let me know if you have an issue.
And so, Your Honor, as I mentioned, we don't intend to dispute the reasonability of Mr. Freed or any of the attorneys in this case hourly rate. We do have questions about some portions of the fees presented, and I want to walk you through those objections. The first is related to recovery of fees related to insurance. I think this is what we're referring to as the third-party claims. I need to start by disagreeing with one aspect of the way I think the case is being presented on the facts now. As you heard the defendants say, there was never any basis for bringing this suit. And I do think that's quite explicitly a different position than what they took in the October 17th hearing. Their defense counsel said, quote, "It is reasonable on some level that a lawsuit was filed. Nobody is contesting that." And it sounds like now that they've won the fee petition, they backed up a little bit to claim that the lawsuit never should have been filed. We don't think that's right. We think there was a good faith basis for filing a lawsuit and pursuing discovery on this matter. And even more clearly, there was a basis for asserting a claim. The reason why I raise that is because a lot of expenses listed on the invoices are related to what it sounds like was a very difficult process for defendants in attempting to obtain insurance coverage and asserting claims against insurers. And it seems to me that their efforts to seek coverage followed as a result of this unfortunate incident, not as a result of any conduct that occurred in this litigation. And so we agree that to the extent that there are records in invoicing that are really related to third-party claims, to attempts to collect on insurance, that portion ought to be excluded from the bill. Now, Your Honor asked a question about looking through the invoicing. I will say, I think that $42,000 number, I assume it's made in good faith, but I think it's the first time I've seen that total. I do find it a little bit difficult to determine from the face of the invoices what is included in that, because sometimes a time record will specifically reference third-party claims. Sometimes it might say, have a telephone conference to discuss insurance coverage issues. Or I think in one instance, there was a fairly significant expense where they were tracking down a witness related to insurance coverage. It's not obvious to me, based on that $42,000 number, which items on the invoice are being included in that amount. So if there is some option for defendants to color code or highlight, I think that would be useful in determining the scope of the amount. But our request to the court would be that the court exclude insurance coverage and third-party claims, because those are not conduct or litigation that was incurred as a result of the conduct that the court on which the court is basing its sanction. The second category we want to address is that it seems like there are some unevidenced portions of fees. I've done my best to try to reconstruct the records, and it looks like, as Mr. Grant said, there was one transmission of a significant amount of billing records and then a supplement made relatively recently. The main omission that I can't quite account for is it seems like from Freed Grant's bills, there are thorough invoicing from 2016 to 2018, the beginning of 2018, and then there's a gap for most of 2018 and 2019 and the beginning of 2020. If those bills are in there, I can't find that. I think there's probably a big chunk of that is attributable to the appeal, and that might be why those bills are missing, but it seems like there's at least some that can't be explained for that. For example, I believe that briefing on the renewed sanctions motion falls within that period, and I couldn't find any light item in the bills for those sanctions motions. And so to the extent that those bills are being asserted, we'd like an opportunity to review what those bills were and look at them. Particularly for the next reason I'll get to, which is that we do think there is some excessive and or duplicative billing on the sanctions motion. As the court may recall, when it decided to award fees, it mentioned, quote, "We've had the same arguments presented multiple times, so there may be, although I'm not saying there is, but there may be some duplication that might need culling." And in my review of the records, it does appear to us there are some excessive amount of hours billed specifically on the motion for fees. And because of that gap in the record that I mentioned, it's difficult to ascertain whether there is duplicative billing on those fees. So what I was able to find from the invoicing, it appears to me that on the initial motion for fees, there was a little more than 70 hours spent drafting the motion itself, another 32 hours on the reply brief, and 32 hours on hearing prep, which quite frankly, we do think is an excessive amount of time for what admittedly was a complicated procedural issue, but one that we don't necessarily see as needing several weeks worth of attorney time to perfect. Then on the renewed motion for the fees, we could only find about 2.2 hours attributable to the motion itself. Now, obviously, if it only took them 2.2 hours and that's all they're requesting, we think that's reasonable, but we have a concern that where there seems to be a gap in invoicing, there may be additional hours attributable to it. As the court mentioned in the hearing, depending on that amount, that might affect the court's assessment of reasonability. Because if there was a significant amount of hours on the renewed motion for fees, the court might view that as partially redundant with drafting the initial motion. What does appear to be from that record is time spent on hearing prep for the renewed motion for fees, which was more than 47 hours, which we do think is excessive. And I'd point inside that 47 hours, as far as I could tell, there were 12 plus hours alone researching how to prevent the plaintiff's attorneys from discharging the attorney's fee award in bankruptcy, which to me is not a reimbursable expense. It's not a ripe dispute yet, and it's an excessive amount of time. So our request would be that if defense is seeking time for the period of the invoices that we can account for, that they provide those so we can look at it and the court can look at it and make a determination about whether it's duplicative. And then we'd request that the court make its own assessment about what is a total amount of reasonable time to be spent on briefing and hearing prep for the motion for fees, and sort of cap the reimbursable attorney's fees based on this court's assessment and its discretion of what was a reasonable amount of time to spend. And then the final area we wanted to address with the court is when the fees begin to accrue. As a way of reminder, the touchstone under 915.14 for attorney's fees is at what point there existed such a complete absence of any justiciable issue of law or fact that it could not be reasonably believed that a court would accept the asserted claim, defense, or other position. Now, we think the earliest this point could have occurred was September 15th, 2016, which, as Mr. Grant explained, was when the defendants produced a copy of the videotape along with a letter outlining why they don't believe the videotape supported plaintiff's claims. At least in that initial fee hearing, counsel agreed that it wasn't unreasonable to file the suit, nor was it unreasonable to get into some amount of discovery and attempt to determine whether there was a valid suit there. And so based on that, it seems to us the earliest it could have been the case that plaintiff's counsel needed to conclude there was a complete absence of any justiciable issue was when they received that videotape and had a chance to review it. So we think at a minimum, the court should say the amount of costs is compensable only after September 15th. However, what we believe the court should do is consider accruing costs only after October 16th, 2017. That was the date of the hearing on the initial fee motion. And I want to talk a little bit about why we think that's appropriate. One thing I want to highlight, I know that Mr. Freed had a lot of frustration on the fact that there was a renewal action filed in advance of the mediation. And I want to highlight what we view as an important difference about the renewal action. You know, this court was very concerned with what was the plaintiff's counsel's basis for believing that there was a crossfire in front of the club. And the crossfire narrative, as Mr. Grant refers to it, they've identified as coming from paragraph 10 of the initial complaint, which I put up at the top of this slide, where that complaint specifically alleged that there was a shootout in the parking lot from people who had exited the front of the club. When the case was dismissed and refiled, after plaintiff's counsel had received the videotape and had a chance to review that videotape, notably that allegation is changed to say that the driver was struck from a decedent who had left, from an individual who had left Magic City. And that is because the plaintiffs were attempting to pursue this case under multiple theories. First was the crossfire narrative that after the video was produced was removed from the case and the case was dismissed. Second, the theory that plaintiff's counsel continued to develop during discovery, and that I think is well explained in the appellate briefing on this matter, is that the assailant appears to have left. There was this melee in the club. The assailant appears to have left out of the back door of the club, as Mr. Grant points out. And plaintiffs believed that the club had an obligation when there was a scrum inside of the club to maintain control over its exits, control access and egress, and take certain preventative measures when there is a fight in the club to prevent secondary effects of that fight outside of the premises. We thought that theory was a persuasive theory because the club has an obligation to maintain control of its premises. There clearly is an argument for proximate causation in that circumstance, because had the club shut its back door and refused to allow egress out its back door, the assailant never would have been outside to shoot the victim. And it also addresses Mr. Freed's point about ownership of the premises, because clearly, whether or not Magic City controlled the parking lot, it certainly controlled its back door. And so that was the theory that the plaintiffs were attempting to advance and attempting to develop in 2017. The reason I raise all of this is because we believe that the plaintiff's counsel had reasonable basis for believing that that claim potentially could have persuaded a court. And the earliest that we think it can fairly be said that was not possible was when this court made quite clear in its October hearing, first, that it was putting plaintiff's counsel on notice that it wanted the discovery to proceed better, it wanted cleaner discovery, and it wanted the case moving. And second, that it invited a summary judgment motion because the court was skeptical of plaintiff's claims. So, well, plaintiffs take the position that we always had a good faith basis for pursuing a claim. We'd certainly agree that for purposes of the statute, the earliest moment at which plaintiff's counsel was on clear notice that they did not have a reasonable chance of winning this case in front of a court was when the court told them that in the October hearing. And so we'd suggest that the October date is a reasonable departure date for the beginning of incurrence of penalties. Based on that, plaintiff's proposed approach would be that the court doesn't act on the fee petition at this time, but it specifies that a renewed bill of costs should comply with the following terms. would exclude time spent on insurance coverage issues or relating to perfecting claims against third parties, or at least use a color code to identify it for the court so the court can make its own decision. We'd ask that the court cap the total time on sanctions motions at an amount that it deems reasonable. We'd ask third that the renewed filings either exclude the time that's not supported by the current time records where we think that's a gap, or if that's just an omission and they want to submit those time records, submit them so we have a chance to review them. And then finally, that the court state that only time incurred either after October 6, 2017, or in the alternative after September 15th, 2016 is reimbursable. Unless the court has any other questions, that concludes my presentation.
All right, so,
Your Honor, may I respond briefly?
yes, sir, Mr. Freed.
I'll wait to counsel withdraws. Thank you, Your Honor. So I'm going through the invoices that I have. I don't remember the date specifically that Mr. Kastorf mentioned, but there are invoices for January of 18, February 18, April 18, July 18, October 18, December 18, March of 19, April of 19, May of 19, June of 19, October of 19, May of 20, June of 20, and July of 20. So perhaps counsel didn't get a complete set, but going through the notebook I was presented, that includes the invoices that our paralegal compiled, those invoices are included. So we're happy to provide Mr. Kastorf with a complete set of those invoices in case Mr. Washington or whomever on his side of the coin didn't get those to him, but those are all there. We did try to admit the invoices for the appeal since they are legally irrelevant. I will say this, you can't lock a back door. It's an emergency exit. By code, you have to have two doors to a facility like this. And there was a melee inside, but the plaintiff decedent was one of those people in the melee. They went out the front door, the shooter ran out the back door. So if he's saying you can't lock the back door, can't let people leave the back door, that's just not an appropriate mechanism.
Mr. Freed, you don't even have to argue that. That's long, that issue has long since been resolved both by me and the Court of Appeal.
Thank you, Your Honor.
Your Honor, if I may just quickly address a couple things. We can certainly provide the invoices. Again, as I said at the outset, the ones that we actually tendered to the court with our November 2020 notice, a large part of the gap is because pretty much we filed the motion for fees right at the time that the appeal was going on. And so that gap is largely just because there were invoices that were exclusively related to the appeals. And so the amounts in those bills, we're happy to furnish them, but those amounts were not included in totals that we have given. And then also just by way of explanation for when the court does look at the documents, with respect to the finding that there are allegedly 70 plus hours spent on the initial motion for fees, I would point out to the court that this is incredibly complex. All of the different proceedings that this thing spanned and the different instances of behavior and the need to show that and document it, and that's evidenced by the many exhibits that comprise about 388 pages that we filed with the appendix in support of our initial motion. And part of that, that's also important because, as Mr. Kastorf noted, there's really not much time related to our renewed motion. And that's frankly, Your Honor, because we had already done so much substantial work. If you look at our renewed motion, it was almost kind of a bullet point recitation because we had to wait during the pendency of the appeal. And then when that was done, Your Honor, we basically came forward and just sort of put our hand up to put it back before the court again. So because we had done all the work, which was quite extensive up to that time, it was already kind of baked into what we had charged. And of course, we didn't want to go reinvent the wheel there. And then again, to kind of piggyback on Mr. Freed's point, we are dealing with officers of the court who have ethical obligations and duties of investigation. they seem to recognize that at the very least, the latest point should be the September 15, 2016 date. I'm certainly not aware of and haven't heard anything presented today or otherwise that would somehow give them a mulligan for essentially a whole nother year. We appreciate that Your Honor made the comments that he did and saw this for what it is. But I don't think that they needed to wait to be told by the court that there wasn't anything there. I mean, as the court noted, the video speaks for itself. The infirmities and misrepresentations with the standing as far as guardianship, probate, and a lot of these other things as far as the failure to interview the witness, Mr. Radel, I just don't see that as any justification whatsoever to get you past September 15, 2016.
So really the difference is between September when y'all first communicated in detail about why you thought the lawsuit had no merit, and then my October hearing when I told them let's get to the merits of this quickly. All right. I think I understand that. All right, so what I'm going to ask counsel for defendants to do is to resubmit submit all of the invoices so that Mr. Kasdorf has access to everything. But specifically carve out or indicate whether you color code it or whether you have some other way of dividing it out, specifically carve out what you're not requesting reimbursement for and why, whether it was related to the appeal issues, whether it was related to the insurance coverage issue. And if you can, and if you think you could do that within the next 30 days?
Absolutely, Your Honor.
Yes,
All right. So then, Mr. Kasdorf, what I'm going to ask from you, and this is really voluntary on your part, but I think it's in your client's best interest, is once you get those, give you 30 days to look through that. I think you've already done some of the work. Then I want you to highlight for me what areas you think they've requested, which invoices or entries and invoices which you think should be either excluded, that they haven't already excluded, or should be dramatically reduced. So I can focus on just the invoices. So tell me, talk to me, point me out where there's time spent on sanctions motions and what that total time is. Or if you think there are other entries that may relate to insurance coverage that they didn't exclude, but point it out to me so I can get a focused look rather than just trying to go through every single entry in detail and trying to figure out what it is that you're challenging, what it is that you're not.
Yes, Your Honor.
And finally, I'll give defense counsel 30 days from then to make any response to what Mr. Kasdorf has challenged. And then with that final briefing, I will enter an order and a number. That sound like a reasonable way to proceed for everyone?
Absolutely, Your Honor.
yes, Your
Yes,
Honor.
Your Honor.
All right, so let's go forward from there. Unless there are any other matters that I need to, evidence that I need, or argument that I need to consider today, we'll conclude the hearing and everyone can be excused.
Thank you, Your Honor. Have a good weekend.
You too. Everybody have a great weekend.